Hi, guys. Let's see. All right. Welcome back. I'm hoping that I fixed my sound problem, but before I start, I'm going to wait this time. And you guys let me know in the comments if you are hearing any kind of craziness. Okay, so we might be working. All right, so I'm gonna give everybody a few minutes to hop back on. I apologize for the problems. Aside from my noisy kid that may sound occasionally, you should not hear high pitched sounds. So, for those of you who are hopping back in and who are joining us for this live stream, I'm just going to go briefly into my intro. I am Marissa B. Grayson. For those of you who do not know me, I am a family law attorney, mediator, and co parent coach, also known as America's Blended Family Expert. I am also the founding and managing attorney of the Collective Legal and Crisis Management Firm. We are a full service law firm and crisis management agency that handles all types of cases from start to finish, both in and out of the courtroom. So not only do we have attorneys on our team, we also have a team of amazing professionals in various industries, from the parenting space to step family and blended family matters to domestic violence recovery, social media, business, litigation, lawsuits, all that good stuff. So again, thank you guys for hopping back on. For those of you who are hopping on the first time, today we're talking about 10 mistakes to avoid in your family court case. So I'm going to do a quick recap of the first three that I already covered, just to make sure that everybody has the information that they need. But basically, the reason I'm deciding to do this topic is because as a family law attorney, I see this over and over and over again. The same mistakes, different people, different places, right? And a lot of times I sit and watch cases and it just makes me cringe because I feel like, if they would have only known not to do, not to say, not to write, not to text, all of that stuff, maybe this person would be in a better situation. So I am here to be a resource. And again, if you have any questions, any comments, feel free to drop them in the comments section. I'm going to be watching. If you have anyone that you know who could use this information, please share this video out. And I'm going to dive right in. So 10 mistakes to avoid in your family court case. Number one that I discussed was taking advice from your non-lawyer friends and family members, right? So just because someone that you know went through a divorce case or a child custody case and it turned out a certain way does not mean that that's what's going to happen in your case, right? So we have to look at your case individually to determine what the best strategy is going to be. What worked for them may not work for you. So just because they say, just simply do this and that'll work, you're going to get half of whatever in your divorce case. Those statements, while it may happen, it may not, right? Because the various circumstances are what's going to impact what's going on in your situation. And no case is exactly the same. So it's just really important that, one, don't lean on your non-lawyer friends for professional legal advice, right? Just like you would not, well, I hope you would not call somebody for some finance advice who has no idea what's going on when it comes to money. Don't do the same when it comes to your family court case, because you might end up in a worse situation than you were in when it all went down or when it all started, right? So that's number one. And number two, if you have been through a family court case, please don't be the friend that's giving your friends or family members advice and telling them what to do without telling them to go and talk to a lawyer or a professional who's familiar with that space to make sure that what you're saying is right, right? Naturally, we're going to have conversations with friends and family members about the things that are going on in our life, right? But as a friend, If someone comes to you and is asking you about your case and how things went and what you needed to do, sure, you can get some assistance with, help with the paperwork if they can help you along that way and things of that nature. But when it all boils down to it, your actual game plan should come from a professional. The actual advice that you're using should come from someone who does this on a regular basis to make sure you're not missing any exceptions or to make sure you're not missing anything in general. So that's number one. Number two, hiring an attorney that is not well versed in family law. Family law is a very specialized area of law, right? So there are, most of the time when I tell people who don't do family law, who are lawyers, when I tell them I do family law, their response is commonly, oh my gosh, how are you doing family law? How do you do that? How do you sleep at night? How do you not let your clients drive you crazy and all of this stuff, right? And that's because family law is not the area of law that you kind of just dabble into, right? It's the area of law that you study, you become familiar with, and you practice in it over and over and over until you understand the way that the process works. So that's not the time to hire your criminal defense or your personal injury friends who are attorneys to come on and try to assist you with your case, because if they don't have knowledge about family law, you might again end up in a situation that you don't need to be in, right? And or end up in a worse situation than you were in before because there was a small nuance specific to family law that they didn't know. So again, just like we're not taking advice from homeboys, homegirls, and family members who are not attorneys, we should also not be hiring attorneys to handle our family court case who don't have experience and knowledge in family law. So that's, make sure you just ask, how much experience do you have? Do you have any? And if you don't, because I was a new lawyer at one point, right? If they don't have any experience in family law, they should have at least invested their time and resources into learning it, right? Because you can do family law if you study it and you practice it. And I teach people who are not attorneys to do this. So I know it's possible, but you don't want to just throw any old person on your case. So that's number two. Number three, not being prepared. That means not knowing what's in your court documents, not knowing the specifics of your case. We need to know dates. We need to know times. We need to know monetary values. If we're talking about, child support, spousal support, or division of assets. So it's really important that you document. And I talk about this all the time, but it's really important that you document, keep track of everything, and that you're prepared. So if you have a hearing, right? And a lot of times I have these consultations with clients, and specifically in my consulting practice through Family Court Academy, where I work on helping people represent themselves in their family court case because they're not hiring a lawyer, right? So a lot of times we'll get on our consultation. I'm like, okay, you got a hearing coming up. What's the hearing about? And then they have no idea what the hearing is about, right? So the hearing will be a day or two later, and we're scrambling trying to figure out what the hearing is about. So read your documents, read your court notices, and know exactly what's going to take place at a particular hearing. Yeah, things might go left. The judge may decide to talk about something different, but at least know the minimum that you're going to be discussing, so you're not blindsided, and so you're prepared, so you know what to take with you. If it's a financial matter, child support, spousal support, things of that nature, requests for attorney's fees, then you know that you're going to probably need to have some financial records with you. So take them with you. So just be prepared. I did not know. I wasn't aware. I was unsure. Just because I'm not a lawyer and I'm representing myself is not an excuse, right? So even if the other parent or the other party does not have a lawyer, it's important that you treat your case, if you're representing yourself, as if you are the lawyer in your case, because you're expected to know the same rules, same laws, follow the same procedure. And I didn't know that I was supposed to file my documents 2 weeks ago is not going to be an excuse, right? So you have to make sure that you at least do your research, prepare, and you got to be ready, right? If you're representing yourself, then chances are you're protecting your own interests. So in order to do so, you got to be diligent. So that's number three. Number four, not following existing court orders. Before I dive into this, if you know anyone who could use this information, please share this video out. If you have any comments or questions, please drop them in the comments section or the comments below. All right. So anywho, not following your existing court orders. Courts, judges, they make orders that you may not like. That's just the reality. It comes with the territory of having your case decided by a court, right? So it's important that you understand, one, that once you've gotten to a place where you and the other parent are not going to agree, the orders may not go your way 100%. And you're just going to have to make them work temporarily until you can get them modified. And, you know, that's a whole nother conversation, shifting up your strategy to change court orders that have been entered that you don't like, right? But in general, self-help to modify your orders and do what you want is not a good look, and the judges don't like it. And a lot of times, again, it'll put you in a situation that was worse than the one that you're in, that you're trying to, you know, avoid the orders for. So follow your court orders. Not only will it piss your judge off if you're not following your court orders, but it could subject you to contempt proceedings, which are semi-criminal in nature. And that means if you're found guilty of contempt, you might go to jail or have to pay substantial fines and fees. The court can order you to pay the other party's attorney's fees and all kinds of stuff. So you just want to make sure that you are doing exactly what you're supposed to be doing in your case. Don't care what the other party's doing. I know they're not violating, they're not following the orders either. I know that you're not getting your phone calls. I know that sometimes they show up late or don't show up at all for visits. I get it. But when you are representing yourself, you need to be able to walk in and say, you know what? I've been following the orders to the T. It's them that's violating left and right. That'll put you in a better position than you saying, well, if they don't follow, I'm not following. So that's just number 4. Number 5, angry. This is my biggest pet peeve, but I get it. Angry or emotional texts, emails, and especially social media posts. Let's talk about that for a minute, because many of us get irritated, right, with the other party, and they might send us an email or call us on the phone and curse us out, hang up in our face, send us crazy texts, come to your house acting a fool, all of this stuff. I get it. But it's nothing worse than showing up to court complaining that the other party is doing X, Y, and Z, but yet you've been acting a fool by text message, email, in talking parents, our family wizard, all of that good stuff. If you guys don't know about that, we'll talk about it in a few. But the important thing is, we as attorneys use social media as evidence all the time, right? And I tell people this all the time, and I still am able to use it all the time because y'all be putting everything on there. I don't need to know everything that happens with you and your baby daddy or your baby mama from Facebook. Like, I don't need to see that. Or if you are claiming, right, that you need more time with your kid or whatever the case may be, but the other parent can pull screenshots of every time the kid is with you, right? When we look at the dates, you at the club, obviously none of us are at the club other than club quarantine right now, but you're at the club every weekend when it's supposed to be your parenting time. That's not a good look for you, right? You posting videos. If you're sitting drinking like crazy, drinking at home and your kids are right there, you know, you're walking around drunk on video, and that ends up on Facebook, Instagram, while your children, you're supposed to be providing for your children. All of these types of things are things that could, you know, come to bite you later on, right? If you claiming that you can't work, so you don't want to pay child support or spousal support, right? You're claiming you don't have any money, but on Instagram, you flossing all your cars that you renting for $1,000 a month, right? Or you're showing all the expensive clothes and the shoes and the jewelry and all of this stuff that you have. What do you think we're going to do with that, right? So you have to make sure that whatever your arguments are, you don't need to be giving us additional evidence that's going to be working against you or giving the opposing party, right? So that is number 5. And the rule of thumb is, if you go on a billboard for the entire world to see, you probably don't want to send that text. You probably don't want to send that, post that message or that rant on Facebook, even if you thought that your account was private, right? Even if you thought that you had blocked everybody who would see it, and some kind of way your ex still has access to your information that you posted. People are scandalous. People be all on your pages. They'll be sending information to your ex and you'll have no idea, thinking they're your friends, right? So just be careful. Don't be putting everything that you don't want everybody to know about on social media. And when it comes to the communication by text, here's something that our communication strategist works with our clients and teaches them. She always says, you are communicating not just for the person you're communicating with, but you're communicating for the people who will see those messages, those posts additionally, right? So if you're sending a message to your ex, just assume you're also sending that same message to the judge. You're also sending that same message to the accountant. You're also sending that same message to the child support workers who are going to be, running the calculations. It's really important that you just understand, though you might think it's a private text or a DM or that people aren't going to be able to find out. Listen, we find all kind of stuff all the time from sources that people would have had no idea that we even would think to reach out to, right? So just gotta watch your back. Be smart about what you're posting, what you're texting. And especially, I know this is a long one because it's a big deal and it happens so much when you're sending messages, angry messages, cursing the other parent out, y'all. Don't be doing that mess in writing, because it makes you look like the crazy person, right? Even if they called you 5 minutes before you put that message in their DMs or their inbox or their text, right? They called you, cursed you out, called you every name in the book. You sitting there, they hang up in your face so you can't respond. Don't then go send an email and say, you just called me and said da 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 da, and then you go off. Because again, it's not what we know, it's what we can prove. And what I can prove from that is that your text messages look like you acting a fool, you cutting up, you going in on somebody, right? You're mad, disrespectful, but you're saying they called you, but what is your proof? Right? So don't get caught up. Don't bite the bait, right? Especially if you know you have a vindictive ex or, opposing party. Don't put yourself in a position where they're just steady testing you, trying to trigger you. And it happens all the time. And I have to walk my clients through this. They're trying to trigger you. Don't fall for it. Don't you send that text. Don't you send that email. You wait a few days and then you respond. So, all right, that's enough of that. The next one is not keeping accurate records of all communication and contact. So, for those of you who do not know, I am America's Blended Family expert, child custody family law attorney, mediator, and co-parent coach. Also, not just because of my professional experience, but because of my personal experience, right? Many of you know my story already, so I won't dive into details, but I am in a blended family. I'm a stepmom, and we have gone through essentially everything that you probably have been through or are going through in your family court case. We had a lengthy custody battle. It was ugly, really ugly. And ultimately, we got out of that ugly space and we all worked together and we were co-parenting and friendly and attending parent-teacher conferences, yada, 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 right? But even once we got to the peaceful space, right, I still made sure that we kept accurate records of everything, even after we were getting along, even though, we were always reaching agreements. We hardly, had disagreements really. And I still kept accurate records. So I have a calendar that I would keep in the car. So I would know when phone calls were made, when visits occurred, how long those visits occurred, how long those phone calls were. Were there any instances? Were there any disagreements? Was there a no-show? Was there a no call? Whatever the case may be. And we document everything because you never know when somebody's going to flip, right? Thankfully, I haven't had to use it, but please believe I will still keep accurate records. So for those of you who are not already a part of Family Court Academy, one thing that I provide is a co-parenting journal, right? And it's a journal, and I'm going to send you guys the link if you want me to email it to you. So essentially, it's a journal that you can keep all of your information in as it relates to co-parenting, with your ex. So dates, times, phone calls, logs, anytime instances happen, there's a note section, I believe, for you to just jot down, special things that happened or not so special things, right? So it's just really important to have somewhere that you keep track of everything. So call logs are great, right? If you have, any of the major phone carriers, there's usually a way for us to access call logs. Text message records, don't delete them. And I mean, don't delete the good ones or the bad ones, or save the screenshots in a folder, every few months. Because what are you going to do? Even if you get along, right? What are you going to do when the other party shows up in court and says, they're always being difficult, they never want to agree on anything, they never want to work with me on X, Y, and Z, right? Well, you whip out those text messages that show, actually, I was unaware that I was always uncooperative, because from January to January of the following year, here are our correspondences, all of our text messages, and I don't see any drama in here. Actually, we're very peaceful. We're agreeing on everything, right? Same thing goes with like timeshare and co-parenting. When it comes to, I have a few cases like this now. Everything is all good while everybody's getting along, right? You're alternating your custody schedules. You may not even have any official orders in place, and you're following your whatever you agree to as far as your schedule goes. And then somebody gets mad, right? And then you have to file a case or open a case or refile a request to change something in your case, whatever the case may be, right? And then what happens? The person that's mad says, they don't even have the kid that much. They only see the kid every other weekend. And you know good and well that you have them every other weekend, also on Tuesday and Thursday, every holiday, every this, every field trip. You volunteer at their class, right? All of this stuff. And they're making these claims. And if you don't have documentation to show it, coming in and saying, well, I've been having them every other weekend and on the weekdays. And they're like, it's not what you know, it's what you can prove, right? So just make sure, again, I don't care how positive and cooperative your relationship is, unfortunately. And that's the family law lawyer speaking, right? Because we always have to be forward thinkers and we got to think ahead. So if you get along, great. Still document it, because one day if you don't get along, you might need that documentation. And yes, it's extra work, but it's still something that needs to be done. So keep accurate records. Oh, that's another thing I wanted to mention, was that I referred to Talking Parents and Our Family Wizard a little while ago. Those of you who are not already using it, especially those of you who are in a high conflict situation, right? You and the other parent have a tumultuous relationship. You don't get along. You're always arguing. There's always a disagreement, a he said, she said battle. Using Talking Parents or Our Family Wizard is much more efficient than trying to keep track of emails, text messages, and phone calls, right? So essentially what these programs are, and I promise I'm not like a rep or anything. I need to be. I wonder if they have affiliate commissions. But anyways, Talking Parents is free. Our Family Wizard is a paid service. I think it's like $100 a year. And essentially, these are two programs that are recognized by the courts as communication platforms for parents who are in divided families, right? So they are essentially like an email system. That's for co-parenting. You send your messages there. You can see when the other parent has read the messages. You can see when they have downloaded or reviewed the documents that you've uploaded there. There's a calendar there, so you can keep track of your child's schedule. And in the end, right, it's great for organization and just keeping all your communication related to your child in one place, right? So you know that there's a doctor's appointment coming up. You put that information in Talking Parents to Our Family Wizard. The other parent can't say, oh, she didn't tell me that there was a doctor's appointment. They didn't tell me what school they wanted to enroll in, right? So there is a trackable way to see how communication is going. And recognize it as a communication system. So if you need it, you hit the download button, right? Talking Parents is free until you need it. And then at that point, you can the documents I think they charge a per page, but it's really not that expensive. I mean, most of my packets are less than $50, and you can certify them as certified records, take them to court with you, and that's your evidence, right? So when they say she didn't provide me with the insurance card for our child, you'll have those records. Actually, I attach them to these talking parents records. Here's the attachment, and they viewed it. Are y'all still there? These internets they don't want me to be great today. Type something in the comments if you guys can hear me. Let me know if my sound is crazy again. I don't know what's going on here. Is anyone there? Can somebody drop something in the comments if you're here? I see people on, but I can't. Okay, still here. Okay, yay, thank you. All right, awesome. So what was I talking about? Because I'm telling you, the internet does not want me to be great. What is going on right now? Not keeping records. Okay, that's what we were talking about. Talking parents. Thank you, DC. All right, so long story short, use Talking Parents or Our Family Wizard if you can. Just propose it. If you're not already using it, even if you're not going to court anytime soon, you can just let the other parent know, right? Hey, heard about this great program. It's called Talking Parents or Our Family Wizard. It allows us to keep all communication related to our kid in one spot. And I want to sign up, right? What the worst thing they could say is no. But if you do have to go back to court, I would just request that the court order it, because judges order it a lot. In pretty much all my cases, my clients are ordered to use that platform. So it's just it's great to save on your attorney's fees, because if I'm your attorney and I got to go through your text messages, right? I got to order them. I got to try to rearrange them and make them make sense. I got to find the attachments. I got to prove that they're authentic, all of this stuff. If I have to just deal with your Talking Parents or Our Family Wizard, I tell you to print them. You send me the PDF and it's there, right? So that's hours and hours you're saving in attorney's fees by using this program as well. So we're trying to be smart about all of our decisions, right? So that's number 5. No, that was number 6. So number 7, signing bad agreements without question. Stipulations, agreements, they're great, right? They're great if you use them, you file them, and you make them into court orders. My problem that I have, and the thing that I see commonly, is specifically if you're not represented, but the other party is represented by an attorney, and they send you an agreement. Most attorneys, we are all officers of the court, right? We're all supposed to operate in integrity. We're all supposed to make sure that we're being honest. But the reality is, y'all know that mess do not be happening, right? So here's what you have to understand. If it's the other party's attorney, I don't care how nice they are. Like, I'm cool. I'm laid back. When I'm not in the courtroom fighting my cases, I talk to the opposing attorneys. We get along great, right? We negotiate. And the same thing with the opposing party. If there's an opposing party, I don't hate you just because your ex hates you and that's my client. I don't know you, right? So I'll be cool with you. We can have a conversation about your case, reach agreements and all of that stuff. But the bottom line is, I'm representing my client, right? And I'm there to protect my client's interests. Now, I'm not going to do no janky stuff. Some lawyers will, but I'm not. And I'm not going to lie, and I'm not going to be deceptive, right? But I'm also going to look out for my client's interests. So know that if you get an agreement from another attorney that's representing the opposing party, one, you need to actually read the agreement. Don't just assume that what they say it says is what it actually says and means. I've seen that happen too many times. Well, they are an attorney. I trusted that they would. Don't do it. 2, If possible, get a consultation with an attorney and have them review it with you and explain it to you in layman's terms to make sure that you understand what you're signing. Because what you don't want to do is sign an agreement that you don't really agree to or understand. And then when it's time to enforce that agreement by the other side, right? And you agree, for example, I have a case where one party, they signed the agreement that says they have to have consent to travel outside of the county in writing, which is great when the parties are getting along, right? But now we are in a situation where the parties don't get along. And now the client, one party can't leave Los Angeles County because the agreement says so, and the other party wants to enforce it. So now they have to go back to court to try to modify the order. And it was because I didn't realize that that's what it said. Read your agreements. Don't just sign stuff blindly, assuming that the other party is being honest and operating in integrity, because we're talking about a family court case. It does not always work that way. So read your stuff, know what it means, especially when it comes to the money stuff. Know what that stuff means and make sure that, again, you talk to a professional so that you can make sure you're not missing anything before you sign it. Keywords: before you sign it. Because trying to undo you signing it is going to cost you way more time and money than you just doing it to begin with. All right, number 8, disparaging the other parent. That means making negative comments about the other party in front of your children in particular. This is mostly relevant for child custody stuff, right? So I don't care how much you hate their daddy or how much you hate their mama or how much they get on your nerves or how many things they do wrong. Specifically, the things that are not putting your child in danger, right? The things that they do to annoy you are not your child's business. You need to talk to your friends about that, your family members, adults. Keep your children out of it, because when your children hear you talking negatively about the other parent, not only does it impact them because they're half of the other parent, right? Y'all may not want to believe that, but if you dogging the other parent, they're going to feel away because they were made by that other parent. So that's one. But number 2, what's going to happen if your child is ever interviewed or has an attorney of their own in your family court case, and they start telling their attorney or the psychologist that's evaluating your case all the horrible things that you've told them about the other parent? That could be considered alienation, and that could get you in a lot of trouble. And it goes both ways, right? If the other parent is doing that to you, that might not work out so well, because the courts like to make sure that custody is given to the parent who's going to facilitate and encourage the relationship with the other parent and the child, not the parent who's going to dog the other parent to the child and do everything that they can to get out of that, to interfere with that situation. So just watch what you say and make sure you watch what other people say. You can't have your friends over and let them be talking all raggedy about the other parent, and your child is in the next room and you think that the child is not listening. You never know what they can hear, right? So if they're within your hearing distance, or if they're around, period, just watch your words, because you, again, don't want that to bite you later on. All right, number 9 is avoidance. And if you guys have questions, drop them in the comments. I'm going to go to the comments after I get to number 10, which is very shortly. So number 9, avoidance. Nothing worse than ignoring those subpoenas to appear in court, or ignoring your petitions that were served on you and not filing a response. And that happens more than I like, right? People come to me, they got a petition in the mail, or they were served by a process server, and 3-4 months have passed and they haven't done anything, right? They missed the deadline to do whatever they were supposed to do because they were avoiding it. They just didn't want to deal with it, right? Like, why do I have to pay child support when I take care of my kids on a regular basis? Why are they asking me for money? Why should I have to pay spousal support when the other parent works? Whatever the case may be. You might be well justified and very correct in what you're saying, but it's not what you know, it's what you can prove, right? So ignoring it is not going to give you the opportunity to actually represent your side of the story. The only way you're going to be able to tell your side of the story is if you are participating in your case. And by avoiding your case, you're putting yourself in a position where the other party could potentially litigate the entire case without your presence, get a default against you, and essentially get everything that they're asking for, even if it's not something that the law would allow for. So just make sure you don't avoid your stuff, right? Like handle your business. And then finally, number 10, not picking your battles wisely and obsessing over irrelevant issues. And this is something that happens in every single case, right? All of my clients know that they tell me things and I'm like, okay, that's great. I'm glad you got that out. That's not relevant here, right? The other parent, depending on where you live, but in many states, the other parent cheating on you 58 times is not going to be a factor when they're deciding on custody. Some states it will have a little influence, but California for sure, they don't care if you cheat. They cheat, you still cheat. You cheated 58 times, they can care less, right? So they still might get custody. So that's not what we focus on in our custody cases. We focus on what's in the best interest of the child. Now, if they're bringing 52 women or men around your child and your child is getting confused and negatively impacted by that, that might be another thing, right? But the fact that they were not faithful to you doesn't necessarily mean they're not a good parent in the court's eyes. Additionally, they're just the fact that they got a new spouse or a new girlfriend, irrelevant in most situations. I mean, now again, if this new person is a sex offender or an abuser or someone who has, a bunch of criminal charges that could impact your child, right? Those factors might be important. But in general, just because you don't like the fact that they've moved on does not mean that that's going to justify them not having custody. So that's not what we're going to focus on while we're handling your case, right? You have to focus on the things that the court is going to use as a factor in making a decision for your child, because that is what's most important. You can feel all day long. This is why I send my clients to therapy. You are experiencing natural feelings, natural anger, natural frustration, all of that stuff. I get it. Been in it, dealt with it. I get it, right? But just understand certain things are relevant, certain things are not. If it's not, we can't hone on that in the family court case. And that's how a lot of people lose, focusing on things that are not relevant versus building up the things that are. So that's 1 through 10, y'all. I have a few bonuses that I will go ahead and share with you in a few minutes. But first, we're going to go over to the comments section. So if you're just now joining, welcome. And thanks for tuning in for my YouTube family. Hi, guys. And for those of you who are not following me on YouTube yet, I am at Marissa V. Grayson. I have lots of videos on child custody, family law, all kinds of stuff. And I am the founder of Family Court Academy, which is a program that teaches people how to represent themselves without a lawyer, but like a lawyer. So let's drop here into the comments section and see what we got. Number 1. Is there a statute of limitations of what may be used against you, such as social media, text messages, and any documentation, etc.? That's a great question. So statute of limitations per se, no, right? So I can take some evidence of someone's, I don't know, let me just example, alcoholism or drug use. Let's roll with drug use. Posting photos 3, 4, or 5 years ago all over social media of you getting high and drunk and laid up and can't hardly move and can't hardly breathe. People are dealing with you and trying to help you maneuver, right? You got all of this stuff. And the other party is trying to make an argument that you're an unfit parent or you shouldn't have visitation because you're a drug addict. Well, that's a situation where I could necessarily probably go back and pull those records, especially if you're denying that you ever had a drug problem, right? Or if you're denying that you say you don't drink alcohol. That's the thing. That's another thing that comes up. People say, I don't even drink. Well, ma'am, you have a big glass of vodka next to your martini glass on your social media page with your kids running around. So don't say you don't drink, say you drink socially or something, you know? So long statute of limitations per se, no. Um, I mean, if it's something that happened years ago, like if there's, let me give you another example. When people have criminal convictions, right? Things happen. You go through life, you get in trouble, you stumble, you know, into situations that you don't have no business being in, right? You put that past behind you, but the other parent, right? Or the other party wants to hold it against you forever. There's some things that I would look at that evidence and say, that's not relevant now. We will have to address it, right? So if we're talking about criminal convictions, if we're talking about, you know, instances of domestic violence or things that actually matter in your case, and we're pulling that stuff up, we're going to try to show, I'm play devil's advocate here. If I'm the attorney fighting against you, it's my goal to show that you are abusive, a drug addict, you know, whatever, an alcoholic, you don't know how to watch your kids, you spank your kids inappropriately, whatever the case may be, right? So we're going to say, use that to establish that there's a pattern of behavior. Flip it. I'm the defense attorney, right? I'm defending you. You're my client, and you're the one that posted all that craziness on social media. Now I'm going to, the narrative's a little bit different, right? Not only was this a thing of the past, we're going to hold ourselves accountable for it. We're going to talk about the things that you've done to improve your life and how that's a mistake and that's, you know, that's not you anymore. All of the positive things that you've done. We're going to highlight your relationship with your kids and your family and your friends and show that you're this amazing individual, and what you did 5 years ago is not relevant anymore. Follow me? So there's no statute of limitations to answer your question, but whether that information is going to be relevant now is really going to depend on the circumstances. So you just need to know, you know, how to make it work or not, depending on which side you're on. So I hope that was helpful. Let's see here. Anybody else got questions? Let's see what this one is. I'm in the family wizard with my co-parent. My co-parent refuses to have my 5-year-old children call me, which is in our court order to do every evening. I have been reminding her weekly. Yeah. So keep documenting. Now, here's another thing that you guys got to understand about documentation. At some point, it starts to feel redundant. You feel like you're doing it over and over and over and over. Like, why do I have to keep documenting all of these missed phone calls? If you get 2 phone calls a week, you document those phone calls 2 times a week, every week, right? If you get a phone call a day, called you for our phone call at 5 p.m. per the court order, you didn't answer, please have our child call back. They don't call back, next time you get the phone call. Called you at 5 p.m. for our phone call today, please have our child call back. Still haven't heard back from the call that was missed yesterday. And yes, it's repetitive over and over and over. But you know what it does? When it's time to go to court, we got a stack this big of talking parents or our family wizard records, right? Where you've tried to facilitate the phone calls. You've got your call logs on your phone that show that you made the call. They can't produce any logs, right, to show that they actually called you back. And at some point, the judge is going to be like, okay, how many calls do we have to miss before we need to do something else here, right? And if we're talking about a contempt action, then this is proof that all of these things have taken place and they're not cooperating. So depending on what court you're in front of, depending on what judge you're in front of, this may take a while. I had one client where we literally had to keep records, and we went back to court a few times because the other party, she kept getting chance after chance after chance for not showing up for visits, right? But ultimately, finally, the next time we went back, we just kept stacking up all of these missed visits, all of these missed phone calls. And the judge was like, you know what? This is however many times that you've been here. You don't answer the phone calls. We got to do something different. And they shifted custody, right? So keep doing it. Even if you take it and it doesn't work out the last time, go back with more, and then go back with more. Because at some point you're going to annoy the judge, and they're going to be annoyed with the fact that they have to keep seeing you because the other parent is not following the orders. So again, if you're in that situation and it feels like you're just doing it, taking all these notes over and over and over, just keep doing it. All right, let's see what else we have. How can you get GPS of where a parent using talking parents suck as state current location? GPS of where they're using talking parents is what I think you're trying to ask. I don't know if you can actually track where the other parent is using messages from, other than tracking the IP address that they may be emailing from and things like that, if you have technology people on your end. But also, in some states, that's not legal. So you need to make sure that you know, if you're trying to track someone specifically and figure out where they are, what they're doing, just be careful and make sure that action and activity is in alignment with the law, because you don't want to be. I know that there was one case that I took from, I believe, North Carolina or South Carolina, and they have these spousal spying rules. And if you get caught doing that, then you end up in a whole mess. So just make sure, you know, that you are following the law. Earlier, you mentioned that judges switch up from case to case, even if the cases are the same. If the law is being obeyed, why is this happening? Great question. So the issue is the nuances, right? And the facts and the circumstances of each case. Because just, you know, as I mentioned before, just because the facts are similar doesn't mean they're exactly the same, right? So you can have a situation where a parent is supposed to have, I don't know, 4 phone calls a week, but the phone call times interfere with extracurricular activities, right? So there might be a little exception there. So when the judges read that particular motion to enforce a phone call order versus enforcing a phone call order where the parent, the child is not in extracurricular activities and is available at that time, then that's how those little, the difference in circumstances is a very minor thing, right? But the difference in those circumstances can make all of the difference. Also, judges are human. And they have family code sections that they have to follow. They have statutes, they have case law, you know, all of these things. But the reality is that judges have a lot of discretion, right? So specifically when it comes to child custody, the main rule is the judge can make orders that they deem to be in the best interest of the child. Well, what exactly does the best interest of the child mean? That's going to depend on that child, right? What's best for my son may not be the same thing that's best for your daughter. So in using that flexibility, the judges will be able to use their discretion. And so when you have one parent that, you know, I'm requesting a specific order for, and then you have a different parent, depending on the opposing party's arguments, the evidence, all of this stuff, they may be able to use that discretion to vary the way that they make their rulings, right? So it's really, again, it happens more so because if there's a law that's very specific and strict, then usually, you know, unless the court is not familiar with the law, and there are family law judges who don't have family law experience, right? So they come in and they have good intentions, but they may not know the law very well. So a lot of times in those cases, I have to do extensive written arguments and educate the judge on the law. That's a whole nother conversation. But so it just depends on what they know, you know, what the exceptions are. And quite frankly, judges are human and they have biases that are natural, right? And though that's not right, though I don't agree with it, it still happens. So we have to know how to combat these different things in order to make sure that whatever is supposed to be happening in your case is actually happening. Let's see. She's in California, and I love her scribe also, but definitely find out. Oh, that's nice. Thank you, Tamika. I appreciate that. My consultations start at $250, depending on your circumstances. If I'm reviewing documents, it's usually around the 500 range and up. And I also do, again, ongoing consulting through my Family Court Academy program, which I'm actually opening enrollment very shortly, in the next week or so. So if you're interested and you're going to be representing yourself and you want to be involved in that program, we'll talk about it at a later day. But long story short, I have sample documents, show you how to find the different laws in your state, how to make different arguments, how to question witnesses, all of these different things that you'll need to know, how to do an opening statement, a closing argument, all of that stuff. I walk you through it step by step so that you can handle your own case like a lawyer. And we have, office hour sessions and things like that, Q&A and special content specifically for the Family Court Academy crew. So thank you, Tamika, for that compliment. I appreciate that. Let's see. My BM, that's baby mama, for those who don't know, is not letting me see my child. I'm having to go to mediation. Yes, it happens. If they're not allowing you to see, again, documentation is key, and mediation hopefully will assist in that process of you getting to see your child. If not, you're going to have to go to the next step, which is having the court make some specific orders that, will hopefully be in your favor. Exposing a child to alternative relationships, such as the same sex. How is this seen in the eyes of the court? If we're talking about same-sex relationships, most places, same-sex marriage is legal, and I don't see the courts having issues with that even before. Just because it's a same-sex relationship doesn't mean that it's an appropriate one in the eyes of the court. So unless that person, rather than focusing on the actual structure or the type of relationship, in most instances, what I see is the focus being on, is that relationship detrimental to the child? Is there some abuse going on or anything that's inappropriate, in that sense? But if not, if there's nothing happening other than the fact that it's a same-sex relationship, that's not necessarily going to impact the case one way or another, in my experience. Let's see. I am being extorted and alienated in South Carolina by the guardian ad litem. GAL stands for guardian ad litem. While mom is deployed, please help. Guardian ad litems, for those of you who don't know what that is, that's essentially like a representative who is supposed to represent your child, and they deal with helping the court make decisions as it relates to your family court case. So if you have a guardian ad litem that is biased in your case, there's probably some sort of process that you can, start to have that guardian ad litem changed to a different one. Of course, you'll more than likely have to have some kind of evidence that backs up your claims, but you definitely should look into that or have an attorney look into that to see if it's possible to have that person removed from your case. Otherwise, your documentation and your evidence is going to have to, it's going to have to show the opposite of whatever they're trying to prove against you. So I would definitely look into seeing specifically what the process is to have a guardian ad litem moved from your case. And since we're talking about having people removed from your case, I know a lot of people like to have, or they hate the judges that are on their case, right? So in most states, there's some kind of process to have the judges removed. But what I've seen is that the key to having the judge removed to your case isn't just going to be, oh, I don't like them, or I don't like the ruling that they give, right? So in California, for example, when we're assigned a judge, we have the right to a peremptory challenge, and we can have that judge changed before we start the case. So if I'm assigned a judge that I know is biased, or that I know is not, the type of judge that I need to be on in front of a particular case, I can immediately request the judge to be changed. Now, what happens if the judge is changed to another judge I don't like? Then I just have to deal with it. The same goes for if you don't request that the judge change, specifically, in situations where you didn't know that the judge wasn't a good judge, then you can't just wait, or you shouldn't just wait until after your case is already in motion and then say, you know what, I don't like this judge, I want to have them removed, because that's not really how it works. And that's a common misconception. So that was just a sidebar. Okay, if a parent takes the child out of the state, how can that be proven? That could be proven through the discovery process if they're not supposed to be taking the child out of the state. So you ask for copies of all travel itineraries. You can ask for, if the child is old enough, obviously you can, get that information from the child some kind of way. If your child has an attorney, have them, they can communicate that to their attorney. There are a bunch of different ways that you can prove it. But if they just left and came right back and your child, wasn't kidnapped or anything, even if it's just one violation, which is still a violation, right? The courts are they're real funny. As if they're when it comes to violating orders, right? A lot of times you're going to have to go back to enforce orders more than one time, unfortunately, because judges give second chances. If you don't follow an order, if you break an order one time or, a couple times, you might not have much consequences, or you might not have much of a remedy. So again, documentation is going to be really important. But the discovery process, again, you have to find a way to get those records for the travel, if that's what you're trying to prove, that they left out of town. If they flew, it'll be a little easier. You could subpoena airline records and, things like that. If they drove, that might be a different story, right? So it's going to depend on the circumstances. How much is your retainer? That's going to depend. Depends on the type of case, depends on the facts, depends on the circumstances, depends on the judge that we're going in front of, and how many times we're going to have to go to court. So it varies from case to case. So if you are looking for representation, feel free to give us a call. Happy to discuss your case with you so we can figure out what the retainer would be for your situation. So anyone else have any questions? Before we head out, we are a little under 4 minutes under the hour mark, minus the technology hiccups earlier. So again, for those of you who are new here, or if you're just watching the replay, thank you for tuning in to 10 Common Mistakes to Avoid in Your Family Court Case. I am Marissa B. Grayson. I'm a child custody and family law attorney, mediator, and co-parent coach, also known as America's Blended Family Expert, also the founder and managing attorney of The Collective Legal, and also the founder and essentially the only attorney right now of Family Court Academy. So if you're looking for more family court information, tips on how to represent yourself, just make sure you check out my YouTube channel. It's been a little bit dormant, but I have like over 5,000 of you guys on my YouTube channel. That's why I keep shouting out my YouTube family. But I'm going to start posting more videos on my YouTube channel regularly. Also on the Family Court Academy's Instagram page, we post information and tips. I have a blog, americasblendedfamilyexpert.com. There's articles, videos there. On my law firm website, yourfamilyslawyers.com, there are videos and articles there. So if you need information, I'm your girl. I put so much information out. All you got to do is Google me, and you'll find a bunch of articles, videos, all kinds of content. And of course, if you need one-on-one legal advice or consultation, feel free to hit me up, shoot me a DM, send a message through my contact forms on my site. Otherwise, thank you all for tuning in and joining me despite my technology snafus. And I will see you next time.